Good evening, everyone. Today we will be reporting Rule 115, the rights of the accused. I am Cherish Ann Agbong, and I have with me Mary Salman Guaza to report this rule. No? So, Rule 115 has 9 rights for the accused. The following are: first, the right to be presumed innocent until the contrary is proved beyond reasonable doubt. Two, second, the right to be informed of the nature and cause of the accusation against him. Third, to be present and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of judgment. Fourth, the right to testify as a witness in his own behalf, to be subject to cross-examination on matters covered by direct examination, and that his silence shall not in any manner prejudice him. Fifth, the right to be exempt from being compelled to be a witness against himself. Sixth, to confront and cross-examine the witnesses against him at trial. Seventh, to have compulsory process issued to secure the attendance of witness and production of other evidence in his behalf. Eighth, to have speedy, impartial, and public trial. And 9, to appeal in all cases allowed in a manner prescribed by law. While Rule 115 provides for 9 rights, we will include another one, which is the right to due process. No? So let's start first with the right to due process. The right to due process, the requirements are as follows. No? That there must be an impartial and competent court with the judicial power to hear and determine the matter before it. Second, the jurisdiction must have been lawfully acquired over the person of the defendant or to have property subject of the proceedings. Third, the defendant must be given opportunity to be heard. And lastly, that the judgment must be rendered upon lawful hearing. In the case of Perez versus PTNT, in criminal cases where the constitutional presumption of innocence exists, procedural judicial due process requires that judgment must be rendered upon lawful hearing where factual issues are tested through direct and cross-examination of witnesses to arrive at a proof beyond reasonable doubt. No? It is clear from the foregoing that the judgment must be rendered only after hearing the factual issues, no, through cross and direct and cross examination, and that the quantum of proof required for a criminal case is proof beyond reasonable doubt. So we will delve on that later on. More on that later when we go through our report. No? So let's go to the first right that is provided for in Rule 115, which is the presumption of innocence. So in all criminal prosecution, the accused shall be presumed innocent until the contrary is proven. This is provided for in Section 14, Paragraph 2 of Article 3 of the Constitution. This presumption, being constitutional in nature, prevails over the presumption of regularity in the performance of official duty. The presumption of regularity obtains only when there is no deviation from the regular performance of duty. That is the reason why that the presumption in criminal offenses, the presumption of regularity attaches only when they have provided evidence that they have not um, derived from the processes required by law, or there's no deviation from the regular performance of duties. No, so the presumption of innocence in criminal cases, no, trumps the presumption of regularity of the performance of official duty. Now, in presumption of innocence, the right means that the presumption must be overcome by guilt beyond reasonable doubt. So guilt beyond reasonable doubt means that there is moral certainty as to the guilt of the accused. This means that guilt beyond reasonable doubt does not mean a degree of proof that excludes possibility of error or produces absolute certainty. So it only requires moral certainty or the degree of proof which produces conviction in the unprejudiced mind. Okay? Accusations is not synonymous to guilt. Conviction should be based on the strength of the evidence of the prosecution and the weakness of the defense. So even if the defense was not able to um, to secure all evidence that is required to defend or yeah, to defend the accused, no, or for example, there are some cases wherein hindi the defense was not able to present evidence, no, the it the prosecution may still end up not winning, no? Because as I said, it is based on the evidence of the prosecution and not on the weakness of the defense. If the prosecution was not able to establish guilt beyond reasonable doubt, then the case may still be judged in favor of the accused. Okay, so what is the exemption of presumption of innocence? The exception here is that if there is reasonable connection between the facts presumed and the facts ultimately proven from the facts ultimately proven. And the second one, in cases of self-defense, the person who invokes self-defense is presumed guilty. On the second exception, if you invoke self-defense, automatically the presumption is that you're guilty. It is upon you to prove that all the requirements, no, or the elements of self-defense is present in your case, so that your criminal liability may be extinguished. Now let's go to the equipoise rule. The equipoise rule states that where the inculpatory facts and circumstances are capable of two or more explanations, one of which is consistent with the innocence of the accused and the other one consistent with his guilt, then the evidence does not fulfill the test of moral certainty and is not sufficient to support a conviction. The equipoise rule provides that where the evidence in a criminal case is evenly balanced, the constitutional presumption of innocence tilts the scale in favor of the accused. Now let's go to the second right, which is the right to be informed of the nature and cause of the accusation. So we have discussed this right in the previous reports, no, especially in the prosecution of an offense, no, or the requirement that the allegations, no, in the complaint or information should have, no, the requirements that it states the causes, the nature and causes of the accused, the acts or omissions complained of constituting the offense, so on and so forth. So that all of those rules, no, stem from the right of the accused to be informed of the nature and cause of the accusations against him. So what is specifically required is that the acts or omissions complained of as constituting the offense, including the qualifying aggravating circumstances, must be stated in ordinary and concise language in terms sufficient to enable a person of common understanding to know the offense, what offense is being charged. No, the ultimate aim here is so that the accused can properly defend himself. So in this right, the it is required, no, by law that the way in which the offense is alleged in the complaint or in the information is in such a way that it is easy for the person, no, the defendant, to properly understand the nature and the cause of the accusation against him, so that he may prepare for his defense, no. So the right here is the rationale. Okay, so to inform the court of the facts alleged, so that they may decide whether they are sufficient in law to support the conviction if warranted, to furnish the accused with a description of the charge against him, which will enable him to make a defense, and lastly, to avail himself of conviction or acquittal for protection against further prosecution for the same cause. So the last one deals with, of course, double jeopardy. Okay. Next, let's talk about the right to be present in trial. To be present and right to be present, no, and defend in person and by counsel at every stage of the proceedings from arraignment to promulgation of judgment. The accused may, however, waive his presence at the trial pursuant to stipulations set forth in the bill unless his presence is specifically ordered by the court for purpose of identification. The absence of the accused without any justifiable cause at the trial of which he had notice shall be considered as a waiver of his right to present thereat. When an accused under custody escapes, shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of counsel. So, the right to be present in trial as provided for in Rule 115, Section 1, paragraph C, is very straightforward with regards to the right of the accused to be present in trial as well as the right for him to defend himself in person. No? Now, the right can be waived as provided for in section 1 paragraph C, no? But it can be waived during arraignment, during promulgation of judgment, except if it is for a light offense. And third, when the presence of the accused is required for purpose of identification unless he admits beforehand that he is the same person charged. So, requisites for a valid trial by absentia. So, trial in absentia happens no when a person is without a justifiable reason does not appear when he is required to appear in court. So, there is a valid trial in absentia when the accused has already been arraigned, when he has been duly notified of the trial, and when he has failed to appear at the trial, but his appearance at the trial, non-appearance at the trial is not or is unjustifiable. So this is the requisites for valid trial by absentia. Okay. Now, let's go to the rights of a person to counsel. So the right of a person to counsel is not only available during it's not available only during trial, but it is available no during all stages of the trial, no. So even prior to the start of the trial, the right to counsel can also be invoked, no. So as shown here in the um, table, no, the times when the right to counsel may be invoked, as well as the kinds, purpose, and choice of in the choice of the accused. So let's go to the kind of counsel that is required for custodial investigation, arraignment, and trial. So the kind of counsel that is required for custodial investigation is the presence of a competent and independent counsel. For arraignment, presence of a competent counsel. And for trial, the presence of an effective counsel. The purpose of counsel in custodial investigation is to protect the accused from being forced to confess. No? And for arraignment, it is informing the accused of the consequences of his plea and the nature and the cause of the accusations against him. And for trial, of course, the purpose of the counsel is to defend. This is to defend the accused. Okay. Not the counsel. For custodial investigation, the choice of the accused with regards to who may be his counsel, no? In custodial investigation, the counsel is of his own choice, no? Preferably of his own choice. Now, for arraignment, the court can appoint a counsel for the accused. So this is the counsel, the official. So if you've been to any court hearings, criminal cases, no, whenever an accused comes to court and to be arraigned, and there is no he has no counsel with him, you will see that the court no will automatically appoint a counsel for him. Usually it's the sitting PAO in the court that will be his counsel to official. So I've seen this many times when I'm in court, no, that the judge will ask, no, do you have your counsel with you? The accused will say no, and the PAO will um, stand up, and then he will consult with the um, accused, no, and tell him of the nature and cause of accusation against him, and does he plead guilty or not guilty, what will happen if he pleads guilty or not guilty. So this is what happens during arraignment, no. So for trial naman, okay, it can be his own choice na um, hindi siya provided by law, no, but usually the choice of it's the choice of the accused, no, is the one that is followed here, or the counsel of his own choice. Next. So the right to counsel, as I said, can be invoked at every stage of the proceedings, even in appeal. However, it can also be waived. The accused is deemed to have waived his right to counsel when he voluntarily submits himself to the jurisdiction of the court and proceeds with his defense. But in two cases, the court held that the defendant cannot raise for the first time on appeal his right to have an attorney. If the question is not raised in the trial court, the prosecution may go to trial. The question will not be considered in the appellate court for the first time when the accused fails to raise it in the lower court. No? So, right of counsel and custodial investigation commences when a person is taken into custody and is singled out as a suspect in the commission of crimes of the crime under investigation. As a rule, no, police lineup is not part of a custodial investigation. Hence, right to counsel guaranteed by the Constitution cannot yet be invoked in this stage. The right to be assisted by counsel attaches only during the custodial investigation and cannot be claimed by an accused during identification in a police lineup. Siyempre, pinapaline up ko pa lang, magsasabi ka na, I invoke my right to counsel. Bawal, hindi pa daw yun siya mag-attach doon ng right. No? So, pwede ka nila ipa-line up even without your counsel present. Okay? So, the next part of the report will be reported by Miss Mary Guaza.
So, hello everyone. I will be discussing right against self-incrimination. So, this right is expressed thusly in two ways. So, no person shall be compelled to be a witness of himself. So, this is provided in Section 17, Article 3 of the 1987 Constitution, and as well as in Section 1, paragraph E of Rule 115 of the Rules of Court. In all criminal prosecutions, the accused shall be entitled to the right to be exempt from being compelled to be a witness against himself. So, next ate. For the right against self-incrimination, it covers the testimonial compulsion only and the compulsion to produce real or physical evidence using the body of the accused. So it cannot be invoked when the state has the right to inspect documents under its police power, such as the documents of corporation. And it can also be invoked when the right against self-incrimination can be invoked in all proceedings instituted by the government. So what are its scopes? So we have two ways. So forced reenactments and written exemplars. So for forced reenactments, we have this covers uncounseled and coerced confessions. So it comes within the ban against self-incrimination. It is also akin to making the accused admit criminal responsibility against his will. On the other hand, in written exemplars, this privilege extends to be giving or furnishing of evidence. So writing is not purely a mechanical art because it requires the application of intelligence and attention. Okay? So what is right of confrontation? So it means that the accused can only be tried using those witnesses that meet him face to face at the trial, who give testimony in his presence, and who may be subject to cross-examination. This is further expounded in the case of People versus Hernandez, wherein it stated that among the fundamental rights of the accused is the right to confront and cross-examine the witnesses against him, but the right of confrontation, guaranteed and secured to the accused, is also a personal privilege which may be waived. Thus, according to the case of U.S. versus Anastasio, the Supreme Court deemed as a waiver of the right of confrontation the admission by the accused that witnesses, if present, would testify to certain facts stated in the affidavit of the prosecution. So, it is also part of due process, the right of confrontation, not only in criminal proceedings, but also in civil proceedings. As in proceedings in administrative tribunals with quasi-judicial power. So, it has twofold purpose. So, first, to afford the accused an opportunity to test the testimony of the witness by cross-examination, and lastly, to allow the judge to observe the deportment of the witness. This is it is expoundly covered in the case of People versus Serio and Lacanila. So this does not apply, as I've said, in preliminary investigation. Next, right to compulsory process. So to compulsory process, so this right can be waived except in the following. It is the right of the accused to have a subpoena or a subpoena ducis tecum issued in his behalf in order to compel the attendance of witnesses and the production of evidence. So what would happen if witness refuses to testify? So we have two events. So the court shall order the witness to give bail or even order his arrest if necessary. And two, failure to obey a subpoena amounts to contempt of court. So um, right to speedy and public and impartial trial. So what does this mean? So for speedy, right to speedy trial, so the trial should be conducted according to the law of criminal procedure and the rules and regulations, and it should be free from vexatious, capricious, and oppressive delays. So what does it mean for public trial? So it means that anyone interested in observing the manner that judge conducts the proceedings in his courtroom may do so. And lastly, for a impartial trial, it must mean that everyone involved in the trial is treated equally and without bias. This right is deemed violated when the proceedings are attended by, first, as I've said, vexatious, capricious, and oppressive delays. Second, when unjustified postponement of the trials are asked for and secured. And lastly, when without cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. So what are the factors to consider for a right to speedy, public, and impartial trial? So we have first the duration of the delay, the reason therefore, assertion of the right or failure to assert it, and lastly, prejudice caused by such delay. So what is the effect of such delay if it happens? So the criminal case then is dismissed, that is equivalent to an acquittal, and double jeopardy may attach. So we have to remember that if the accused wants to exercise his right to a speedy trial, he should first ask for the trial of the case, not for its dismissal. So we have the following pertinent time limits that is important for the right to speedy, impartial, and speedy, public, and impartial trial. So first, 3 days. So from filing of information to raffling and referral to trial court. So we have 3 days between them. So from the date of raffle to arraignment, we have 10 days. So from arraignment then to pre-trial conference, or uh, that is 30 days, or 10 days if accused is under preventive detention. So from arraignment to submission of JAs, we have 20 days. And then from termination of pre-trial conference to trial, we have 30 days or not later than 30 days. From the start of trial to termination of regular trial, so we have 180 days, and if trial by JAs minus the excluded delays or postponement that is described in Section 3, Rule 119 and the Speedy Trial Act, we have 60 days. So, according to the case of Mari and People versus Gonzalez, it stated that as per Section 3 of Rule 119, the only delays that may be excluded from the time limit within which trial must commence are those resulting from proceedings concerning the accused. Okay? The time involved in the proceedings in a petition for the transfer of venue can only be excluded from said time limit if it was the accused who instituted the same. Hence, the time during which the petition for transfer of venue filed by the private complainant is pending cannot be excluded from the time limit of 30 days from receipt of the pre-trial order imposed in Section 1, Rule 119. Okay, burden of proving delays. So where is the burden of proving delays? So if the delay is alleged to have occurred during the given periods, the burden is on the respondent or the accused to prove that the delay was inordinate. However, if the delay is alleged to have occurred beyond the given periods, the burden shifts then to the prosecution to prove that the delay was reasonable under the circumstances and that no prejudice was suffered by the accused as a result of the delay. So, if the defense has the burden of proof, so what must it prove? So first, it must prove that the case is motivated by malice or clearly only politically motivated and is attended by utter lack of evidence. And second, the defense did not contribute to the delay. So, what if the prosecution has the burden of proof? So, it must prove that it followed the prescribed procedure in the conduct of preliminary investigation and in the prosecution of the case. Second, the complexity of the issues and the volume of evidence made the delay inevitable. And lastly, that the no prejudice was suffered by the accused as a result of the delay. This is covered by Kagam versus Sandigan Bayan. Next right, so the right to appeal. So the right to appeal is statutory, and one who seeks to avail of it must comply with the statute or rules. The requirements for perfecting an appeal within the regulatory period specified in the law must be strictly followed as they are considered indispensable interdictions against needless delays. Moreover, the perfection of an appeal in the manner within the period set by law is not only mandatory, but jurisdictional as well. Hence, failure to perfect the same renders the judgment final and executory. And, just as a losing party has the privilege to file an appeal within the prescribed period, so also does the prevailing party have the correlative right to enjoy the finality of a decision in his favor. So that's all. Thank you so much for listening to our report. I'm Mary Selman Guaza.
And I'm Cherish and Agbong. Thank you for hearing us, and that's a wrap. Thank you.
Okay.